Hi, Jason Rosenblum here with another IP Basics, and this is a special one for our of-counsel firm, Thompson Patent Law, and this one's going to be about trademarks and initial considerations for a strong brand. So first off, let's start off with what is a trademark? Trademarks are all about source identification. Where do the products or services come from? Who's the company behind it? Do they have a good reputation or a bad reputation? It could be any word, a slogan, a logo, a combination of a logo and a slogan, a logo and a word mark. And then there's also trade dress. Trade dress is if you think of McDonald's, when you walk into a McDonald's, you know that you're in a McDonald's. That feel, the color scheme, there's a lot of similar elements at every McDonald's. That's all part of trade dress. Trade dress also protects things like product packaging. If you think of the Coca-Cola bottle, that's kind of those waves on the top. So they have a trade dress covering that. So why? Why would you file for a trademark? Well, owning a federal trademark, and we're mostly going to think about federal trademarks here, since most goods are sold over the internet, over between states, you can file for a federal trademark. There is state trademarks that are only good within the particular state that you file for. So 99.998% of our filings are for federal trademarks. It creates a legal presumption that you own the trademark and have the right to use it. Having a registration also creates a deterrent effect. Many people search prior to using a new brand. So hopefully it deters them from even using a brand similar to yours in the first place. But also, once they do, if you send a cease and desist letter to them, having an actual registration carries a lot more weight. You can get more damages, things like that. It gives you the right to commence a federal trademark infringement lawsuit. You can use your US registration as a basis in foreign countries to obtain a registration in those countries sometimes, or sometimes get a priority based off your US application. You can record your registration with Customs and Border Protection to stop importation of infringing goods. This could be done proactively, meaning that you can let Customs and Border Protection know that, hey, we know this person shipped a container that's coming in with infringing goods, or they do a pretty decent job considering how many containers come in to sometimes catch counterfeit products. You can use a federal trademark for the basis of a UDRP proceeding, which is Uniform Dispute Resolution Proceeding, or a cyber squatting proceedings, anti-cyber squatting proceedings in federal, and having the trademark is one of the elements needed for those. You can use a trademark as a basis for a takedown notice to many sites, Amazon, YouTube, eBay, Alibaba, places like that, Etsy, to get them to take down infringing goods. Trademarks have a life cycle like anything else. The one thing to know about trademarks is that they can go forever so long as you keep using them, unlike other areas of intellectual property that do have a timeline where they are only valid for X number of years. So before registration, things we want to look at: the strength of a mark, is it registrable, is it clear for use? So just assessing the different marks before you choose to invest and move forward with a certain brand, slogan, logo. Then during registration, we actually prosecute the mark with the U.S. Patent and Trademark Office. The process can take anywhere on the shorter end. It used to take about 9 to 12 months. But right now, at this time in November of 2021, there was a huge backlog from last year. So it's taking about 8 or 9 months until we even have an application that gets reviewed by the examining attorneys at the USPTO. So we'll see how much more time that adds on the end. But generally, I would say 12 to 18 months is a good timeline for filing to registration. And then once it is registered, you need to ensure that you're using it properly, that you maintain it. By maintaining it, we mean filing your renewals, filing between the 5th and 6th year. You need to show that you're still using the mark, because although a trademark can pretty much last forever, you have to use it in order to be able to maintain that registration. As a trademark owner, also, it's your obligation to police that trademark, meaning if someone's infringing, you need to stop them from infringing. No one else is going to do that for you. And then, of course, you hopefully should be monetizing the trademark. I mean, the whole reason for building these brands and investing money into it is to reap the rewards. In this video, we're really just going to talk about before registration, some of the steps you can take, things you should consider when you're picking your brand so that it'll hopefully be a strong, protectable brand. And here's just a quick flow chart of what it's like. You come up with a couple of different ideas for your brand, do an initial assessment. Is it a strong mark? Is it a weak mark? And we'll go into that a little bit. Then when you narrow down maybe the candidates, you look at clearance, because you want to make sure you're not infringing on someone else's mark. What's going to happen when you file, and how strong of a trademark would this be? And then we normally discuss the report with our clients so that clients can then make a fully informed decision. Do they want to move forward with this brand? Do they want to invest more time and money into building it up, or maybe start from the beginning and go back to one of the other candidates? So, strength of a trademark. It initially starts out with looking at the mark and is it descriptive of the goods or services that you'll be selling? So, generic is, if you think of computer for computers, you cannot protect a generic mark. Descriptive marks may be protected. There's a lot of considerations when a client wants a descriptive mark, whether we should move forward with or not, but it is a weaker trademark. Sometimes you might just wind up on the supplemental register. And then over time, I like to use as an example Staples. When Staples first opened, they were a store that sold staples and other office supplies. That is a descriptive trademark. But over the years, their continuous use and investing in the brand and having thousands of stores, ads on TV, they have acquired distinctiveness, and it has become a strong trademark. Once we get past, next up the chain from descriptive is suggestive marks. They're protectable, but they're also a little weaker than other marks. An example is Quickie Mart. You kind of know what's going on there. It's suggestive. And then we have arbitrary marks, which are actual words, but they're just have nothing to do with the type of service or product, and Apple for computers is one of those. And then you have coined or fanciful trademarks, which are pretty much made up marks that are used on a product. Google's an example of that. One caveat is that it is possible to go from having a very strong mark on the distinctiveness scale. If you think of Xerox, Kleenex, two coined fanciful words that wound up almost losing all their protection because they became the generic word for Kleenex for tissues, Xerox for photocopies. So that's part of the maintenance and using your trademark properly that we mentioned in the prior slide. So let's now talk about clearance and avoiding infringement, and the whole registration, offense and defense. We kind of look at those together, but there is a slightly different analysis. So for trademark clearance, the standard for rejecting an application or for infringement is likelihood of confusion. And under likelihood of confusion, there are a number of factors to be considered. The look of the mark, the goods and services, the type of customers, are they sophisticated? Is it impulse buy? The channels of trade, is this maybe only sold through one website and that's the only place to get it, or is it available generally at a store? Was there any actual confusion already? So there's a whole list of factors, but really the two most important, especially when you're looking at, is it going to be rejected by an examining attorney? The ones that carry the most weight are the similarities in the trademark itself and the similarities in the goods or services. So in doing our due diligence, when you're looking at a mark, you should search to see what else is out there. And here are some due diligence tips that anyone, I think even before they come to us to do a search, should do on their own. Or while you're even having your list of candidates, as you're coming up with names, just start doing some searches. And you can look, the USPTO site. WIPO is the World Intellectual Property Organization, and they have a lot of international trademarks. So you can see what maybe in other countries, especially if you're planning to expand outside the US. And then you should always, search Google, Amazon, eBay, Bing. If there's any specific industry websites, if you're a restaurant, look on Resi, Open Table. If you're beer, wine, alcohol, check, the TTB to see if anyone has a registered brand for a specific alcohol. And then, a lot of service industries, you can check a site like Yelp to see if anyone's using a similar name for your product or service. And let's go back and just do a quick search. Just to let you know, what it looks like. So this is the USPTO.gov site. Click on search our database, and you can go to, so here's, something basic. Let's do, so that's just a basic search. And when I say, goods or services, you'll see here, shows this is for envelopes. Another way to search, sometimes you'll receive, let's see if we just do this. Okay, it doesn't bring back that many more, but 8 records, you could just look through here. If you have more records, just do like ACE. So this is 4,220 records. What you might want to do then is go to the structured one, put ACE, just click on basic index, and you can put paper, just to see if there's any paper goods, and then goods and services. And that cut it down to 106. And then you can look through those to see if there's any issues. So that's one way to do a search. So under likelihood of confusion, comparison of the trademarks, we're looking to sound, sight, similar meaning. For sound, a question clients often ask me is, well, if I spell it differently, can I use it? In most cases, no. They do look at phonetic equivalents. So, as you can see here, Xseed and Xseed, or Cresco and Cresco with a K, those were rejected based upon each other. They're found to be too similar. Sight is, if it's a logo mark, you look at the two next to each other, sometimes even word marks, it's looking at the two, and is there going to be confusion between those marks? And then similar meanings, one of the hard parts is we look at foreign equivalents and translations, or potentially definitions. Uh, a lot of these with the similar meanings really plays on the overall commercial impression and what other marks are out there. So that's where it gets really tricky for, oh, someone that's not an attorney that doesn't deal with this every day to look at the list of results and see if there's going to be potential issue. It's not just, is there an exact hit? Is there someone using that exact mark? A lot of times clients are able to obtain a business name because business names are only registered with the state in the US. And by changing one letter or adding an extra word, the states usually will let you register that business name, even if there's a business with a similar name. That's not how trademarks work. Trademarks are all about likelihood of confusion. Would consumers be confused as to the source of the goods or services? One big warning sign is if your potential candidate remind you of a competitor's, don't use it. You're going to have issues. I've had clients that have straight up told me that, oh, we took this because we came up with this name because it reminds us of, whoever the big player is in the field. And that's generally a big warning sign, a flag that you should go to your next candidate. So when we're comparing the goods and services, one of the things to know is that when two trademarks are identical, like the actual word mark or the logo, the closer those are, the lesser degree of similarity you need between the goods and services for a likelihood of confusion. Also, when the goods or services are nearly identical, then you need a lesser degree of similarity between the marks to find a likelihood of confusion. And here's some examples. So Space Pack and Space Bag for storage bags were both found to be like a likelihood of confusion. Trinity for handbags was confusable with Trinity for jewelry. Merlin for watches was confusable with Merlin for clothing. And then Sugar Beach for women's clothing, confusable with Sugar Beach for bath and body care. So that's just some examples to show you that with Space Pack and Space Bag, it's the same exact product. So even though there was the different word at the end, it was too close. And then Trinity for handbags is the same as, they ruled Trinity for handbags is the same as Trinity for jewelry because the words are exactly the same, so the goods could be a little further apart. Same thing with Merlin for watches and clothing, and same thing for Sugar Beach for women's clothing and body care products. Some other areas where they find confusion a lot with the goods being close that me and many of my colleagues have a difference with is with alcohol in restaurants. They seem to think any beer, any wine, any alcoholic product are all related, that consumers can't tell the difference between them. And a lot of times they'll also extend that even to restaurants because there are restaurants that have their own private label wines. There's a lot of, these days brewery restaurants that make their own beer. So they're continuing to find those. Those have been very tricky over the last couple of years that we see a lot of confusion. So, of course, reach out to us if you have any questions. But Jason Rosenblum here of Counsel to Thompson Patent Law, and reach out. Any questions, you can always find us at jhrlegal.com or thompsonpatentlaw.com. Thanks for listening.